might make a start soon. But before we do, as always, is there any questions so far about the course? How are we feeling so far? Good for a Thursday? What I thought we could do this evening was just to quickly go through a real brief recap of week one, because this weekend, as you'll understand, there's a MCQ starting. So that's your first bit of assessment for the course. It's worth 10% of your overall grades. So the multiple choice quiz is something that you'll complete online at the end of this week, so tomorrow, Saturday, Sunday. Now, although you get the whole weekend to do that quiz, it'll only be open, so once you click commence, you'll only get 1 hour to complete it. So although you've got the whole weekend, you'll just get that 1 hour. So just make sure you save yourself enough time so that you've got that period uninterrupted. The quiz will only cover content from week one. So it won't have any negligence on just week one. So the Australian legal system stuff that we covered in the start of this, just week one. Now your textbook, the chapter goes into negligence, but you don't need to cover that. So even all of chapter one, you don't need to cover, just the Australian legal system stuff. So all of week one's examinable or assessable. So you probably best to read the textbook and get across the background in there, and then the slides are a good summary. But definitely the textbook and then the slides. So the quiz itself is 20 multiple choice questions, and each question will get 1 out of 5 possible answers, and you select one of those, which is generally the best answer. Sometimes you'll be able to see very quickly which answers are not correct and cancel them out, but just make sure you read the questions very, very carefully, because they might try to trick you with language such as this is something that does not versus this is something that does. So you can see how that would change your response very quickly.
Is there any negative marking?
Negative marking? No. So you only get the marks that you get. You won't lose any marks. So if you get 18 right, you'll get your 9 out of 10 marks for the semester. In past semester, students have performed really well at the MCQ, usually average between 75 to 80%. So it's a very good opportunity to get some early runs on the board in terms of your overall grades. Have a go at the practice MCQ, which is on Canvas, because that will give you a great example of the type of questions to expect. Pretty much the best way you can practice is to have a go at that. In terms of how the quiz works, you'll get 1 question at a time. So you won't get all 20 questions up front. And when you get your 1 question at a time, once you do select an answer and then click next, you won't be able to come back to it. So from that aspect, you need to make sure that you just take the time to respond to each question carefully. So you'll have approximately 3 minutes per question if we break down. And for the most part, students finish this quiz in 20 minutes. So it's usually fairly quick. So you've got time to sit down and look for your answers and respond in a way. Now, textbook's a great resource, the notes are a great resource, but just be careful that these quizzes are about recall and your ability to find information. So just be familiar with where the text and which each part of the text is at. I always like having my own notes because you can quickly identify where the material is, but you don't have to. If you know your way around the textbook, it's probably sufficient. Any questions about the MCQ? Yep, automatic feedback. But in saying that, everyone will have a different quiz. So you can take a screenshot and send it to your friend. They're going to have a different quiz. So don't go, hey, you do it first and then give me your answers, because it just doesn't work. But you will get your marks straight away. The thing that you won't get, though, is the detail as to which questions you got wrong. Now, after the quiz, I'll give some generic feedback as to the type of questions that students found more difficult than others. But if you want specific feedback, you'll have to come to me directly and I'll unpack it with you. But that won't be until after everyone has completed the quiz. But you'll definitely get your grade, which, let's be honest, is that what we're interested in? Yeah. Hey, how you going? So what I thought we'll do tonight, in the interest of getting as prepared as we can for the MCQ, I thought we'd spend the first half an hour just recapping on week 1, if everyone's interested. Yeah, we'll have just on the key things that I think are important and where you can, I'm not going to give you the answers, but where if I'm talking about something, maybe it's a focus point. And then we'll move into the week 3 content. That sound good? Now, to access the quiz, it's just through Canvas. So you just go into your normal Business Corporations Law shell, click on quizzes, and then the MCQ should be available. Now, you get from the weekend, but I'll release it Friday night sometime. So if you're not one of those people that like to do things on the weekend, you've got an opportunity to do it Friday night. Totally up to you guys. I will publish these slides, but I will say that they're pretty much the same as week 1 anyway. So you do already have these slides. It's just a way of recapping. And I have to disclaim, because that's what we do as lawyers, that it's not intended to go over everything. So although I might not talk about something tonight, doesn't necessarily mean that it might not pop up on the quiz. You need to make sure you read the materials and have a look at the stuff on Canvas. So I don't want someone coming back saying, hey, you know, on week 3 you said this, but didn't come up, or vice versa. But anyway, what did we start with? We started with this question, what is law? And it's a very broad question and something that has a range of different answers for a different range of reasons. But generally speaking, we're talking about a rule that is enforceable by a court. That is the essence of what a law is. So it's something that's enforceable. And for us, we have 2 main sources of law. The first one being?
Common law.
Case law. Excellent. So we've got judge-made law. I heard constitution, but what is the constitution? It's not quite common law. Statutory. Excellent. So we're looking at 2 things, legislative and judge-made law. There's also a third that I probably didn't cover in enough detail, but what happens when legislation delegates the power to a minister, for example, to create laws? We see things called regulations, and you may be familiar with them, but regulations aren't generally passed by Parliament. What Parliament will do in an act is give delegated power to the minister to pass what we call delegated legislation. So regulations have the same impact in that they're legally binding, but they don't have to go through the whole Parliament process. So you've got legislative law, case law. And for us, the law can be classified in a number of different ways. So we've got, of course, common law and statutory law. Common law being the judge-made law. We've also got criminal versus excellent. So we've got a few different legal systems in terms of the laws that come under that. We've also got common law legal systems and civil law legal systems. Excellent. So it's really important that you understand the differences between the terms and what the characteristics are there. You may have a question that asks for what is a main characteristic of the civil law legal system in comparison to the common law legal system. So we can talk about that as we go through. There's heaps of different areas of law. When we talk about specific areas, we might think about things such as tax law, environmental law, human relations, those type of things. That's what we mean by specific areas. And of course, when we're looking at a civil or a company law aspect, those specific laws will be in that civil space. But if we're looking at criminal laws, we might be looking also at tax law as well. But things like the Criminal Act, murder, speeding, those type of things. So the rule of law, incredibly important concept for us, because this is what underpins the governing framework of law. It's also a good way of pointing out the importance of legal theory. So we have some legal theories around how the law is applied, one of them being positive legal theory, which means that no matter what the law is, people have to comply with it, even if it's not fair. That's what positive law means. Whereas we look at natural legal theories, we're more concerned with, well, what is fair and what is morally right? The rule of law sits above that a little bit as well, in that it's telling us that whatever your legal principles are, there is not one individual that is above them. So this means that the law applies equally to everyone, no matter who you are. If you're the Prime Minister, you're still subject to the laws and the powers of the courts to adjudicate those laws. Now, legal systems that have a strong rule of law generally have strong economic wealth as well, or performance. You'll see a lot of countries with poor rule of law, or if we look at the index, where they've got lots of corruption, for example, or dictatorships, the economic performance is actually usually down. And the reason why this, and this is probably a speculation from my perspective, but because rule of law brings certainty, and when there's no certainty, why would we do business? Because we're not really sure how that deal will end up for us. And we'll look at that in contract law this evening in terms of making things enforceable and entering deals because we know we're going to get something back as we've promised. So, most important aspect is the law applies equally to all, whether you're the king, the queen, the prime minister. And the courts will uphold those legal rights in a way that is fair. Now, another important aspect of the rule of law is this separation of powers, because that really underpins this concept of no one being in a position that's above the law. So in Australia, what's our three different branches? Excellent. So we've got heaps there. We've got the executive, who administer the laws. We've got the judiciary. Excellent. So they adjudicate and apply. And then we've got the legislative, who create the laws. Excellent. So they're passing acts, statutes, and other laws. That's really what underpins our legal system, this separation of powers. But when we look at the rule of law, think about fairness and a system that creates or underpins that fairness. And a strong element of fairness is justice. Now, there are two different ways of describing justice. I guess the first one is retributive, which means to punish someone. If we think of a punishment, we can think imprisonment or a penalty or a fine. We've also got restorative justice, which is not necessarily about punishing someone, but recognising the notion that we should restore individuals to a position they were in before the harm occurred. But it's also about the perpetrator being reintegrated back into society. Because if you don't restore that individual, then really they're going to come back out and reoffend and do the same thing. So restorative justice is about that rehabilitation of the individual. So rather than sending them to jail, we might send them to a program if they've committed a crime, a drug rehabilitation program or a counselling program, in the hope that that stops them from going back and reoffending. Because really that's what the purpose is. Justice can be divided in a few ways, which we call distributing it. So justice might be meted out in a way that is equal. So if you commit the same crime, you'll do the same time, in essence. But we know that's not always true, because individuals will get lesser sentences for things that appear to be the same or worse. Now, we can start to divide it up into different categories called utility, in terms of, well, what maximises justice for the system. And we can come back to thinking about, well, restoration itself. Someone who is less likely to offend again is less likely to be punished in the same way as someone who is going to reoffend. So you can see how justice in those aspects is divided in a different way. Also note, justice can mean procedural justice, such as a fair trial, being brought to trial in a timely fashion. so that you're not waiting to be tried for 3 or 4 years like some other jurisdictions. And also making sure that the rules around evidence protect you from arbitrary justice. So you don't want a situation where the police have planted something on you and you've gone to trial, and if there was no rules of evidence, it gets admitted and you get a sentence. These rules are to protect individuals from that arbitrary power. So from that aspect, I think it's really important that you know the legal theories and also the different types of justice, and particularly the rule of law. So 2 different types. Remember, we were saying there's criminal law and civil law. Criminal law or wrongs against society are brought by the Crown or the prosecution. For Victoria, it will be the state bringing those actions. Now, civil law cases are more about wrongs between individuals, and we saw last week in negligence how someone's wrongful act could cause another person to suffer from a harm. That person that suffered from a harm will bring a case in civil law to try and get some compensation. But the state doesn't really interfere in that system other than by setting up a structure for those individuals to have that resolution. Now, the main thing I want us to look at is that the burden of proof is different between a criminal law case and a civil law case. The burden is so much higher in criminal law because we're looking at people's justice and people's liberty. So you've got to prove beyond reasonable doubt that they did something, such as murder. Whereas in negligence, we just need to prove on the balance of probabilities that the duty of care was owed and that duty of care was breached. In a criminal law system, we're looking at punishing, generally. In a civil law system, we're looking at compensation, so some money. What do you sue for? Dollars, generally. Unless you've got a principle-based approach, which is sometimes what happens. You may get a question that asks about the difference between criminal law and civil law, and you should understand the characteristics of each, and what the burdens are, who's bringing the cases. So separation of powers, as I was noting before, incredibly important concept in our legal system and the way that we operate. We've already touched on the 3 different parts. It's good and important for you to know what each of those organs do or what their role is in the system. It's also worth pointing out that sometimes the separation isn't always that clear. And why might that be? Where does some of these lines blur? Excellent. So there's a bit of crossover between the exec and the parliament. So the people that we elect into parliament are also, if they're ministers and the like, administering the laws as executive. So there is a little bit of crossover between statute and the way they're administered, but the judiciary is still separate in a sense. But for the most part, just think about being separate. What binds them? So judges are bound by the law as well. So they have to follow statute. In terms of if there's an act, they have to follow the words of that act. The executive appoints them. These guys. Yeah. So there is some influence in terms of, well, I'll put judges that I think are going to agree with me in the seat. And they will. Yeah. Excellent. They're still independent from the different organs in the sense that judges aren't going to arrest anyone like the executive will. because the executive include the police and those type of prosecutors. So the judges won't arrest anyone. They do make law, but not statutory law. The law that they make is case-made law, which enhances statutory law, I'd say, but also enables them to fill gaps when there's not a law there. So let's say Parliament haven't yet passed a law and something has happened. The judges can at least make something on the spot, in a way, to ensure that it can be adjudicated until these guys and girls decide to pass something that will cover that. But they don't necessarily have to answer to anyone in terms of their decisions are made. There's supposed to be no influence in those decisions. A good point. So absolutely know this. Don't worry too much about the blurring of the lines. I'll probably confuse, but the main thing is to think of it as 3 different organs. And this is our Australian legal system, the characteristics of which we are a representative democracy. So we elect people into Parliament to represent us, hopefully represent our views. And if they don't, what happens is we vote at the next election in a different way, generally. We're a common law legal system, which means, exactly as you pointed out, we've got case-made law and statutory law. Those 2 things form our system. And then the biggest one for me is we're a constitutional monarchy. We have this constitution that underpins our framework, gives the Commonwealth Federation powers to pass laws in the areas that it allows it to. We're still a monarchy because we've got the Queen at the top, head of the state. Now, who represents the Queen, though, because she's not here all the time?
Governor-General.
Excellent. So the representative for the Queen is the Governor-General. Now, one thing to not get confused with is the Prime Minister is not the head of the state. The Prime Minister is the head of the political power that is in government. And what we mean by that is they've got the majority in the House of Representatives to form a government. And then by convention, they become a leader and generally the spokesman for everything that occurs there. But they are not the head of the state. They are just the head of the political party. The Governor-General is the head of the state. Constitution. Good idea to brush up on the different powers that are given under the Constitution. So we've got, 3 powers. That's the separation of powers. But when we talk about powers under the Constitution, we've got 3 other descriptions. They do still support the separation of powers. The first one we can talk about is exclusive powers. And what this means is that the Constitution has given the Commonwealth Government the exclusive power to pass legislation there. That means that no other state parliament can pass laws in an area that has been exclusively given to the Commonwealth. What might be an example of that? Taxes?
Coinage.
Which one?
Coinage.
Coinage, sorry? Coinage. Yep, excellent. Customs, excellent. Defence. Postal, yep. So these type of things that we're starting to see as uniform across the Federation. Just be careful with tax. It's not something that's exclusive per se. It's something that the states actually referred off and then were never able to get back because the Commonwealth raised the taxes so high that if the states were to do it also, there'd be an outrage. So interesting political power balance after that World War that created such an awkward situation. But exclusive powers solely to the Commonwealth. Concurrent powers mean that both the state and the Commonwealth can pass laws in that area. Keeping in mind, though, if the Commonwealth passes a law that is inconsistent or the state passes a law that's inconsistent with the Commonwealth's law, who prevails?
Parliament.
Excellent. So Commonwealth prevails because of Section 109. Absolutely know that section. We know 1901 was the date. I don't talk too much about historical dates or the underpinnings there, but I think it's a good idea if you just read through that part of your chapter that goes through the historical aspects of, for example, when the Australia Act was passed or when those state acts started to come into place. Just a good idea to know when those dates happen. We're looking after a period after landing in the 1788, I think, and then the passing of the colonies into their own constitutions, and then eventually in 1901 we started to see a federation. That wasn't the end of our connection with England though. There were still some situations whereby you could take a case to the House of Lords in England to get heard, equivalent to a High Court. So before the Australia Act and other cases, other legislation like that, we had a court above the High Court. But now, we absolutely do not. The High Court is the highest court you can go to in Australia. Sorry? Are you going to be examined on the dates? I can't say 100%, but I think it's a good idea to know what the dates are, because you can find them. If it says something about what date was this act passed, you should be able to locate that in your text. But I don't think it's important that you know those dates verbatim or off the top of your head. That's what I think I'm getting at. You may get a question, but you don't need to remember them. Let's go back and use your resources. Changing the constitution and the process is important too. Now, it's called a referendum. Excellent. Now, only 8 out of 44 have passed since the constitution first started. Why might that be? Difficult. It's a very high threshold. And what are those thresholds? What has to happen first? Excellent. So we've got to go past both houses, House of Representatives.
Majority of states.
Majority of states need to vote for it as well. And a majority of the voters. So if you take the Parliament section, so it goes through the House of Representatives, goes through the Senate, gets approved by those two bodies, it's then got to be released to the public for a vote. And for it to be successful in the vote, it needs to pass what we call a double majority. And a double majority means majority of the states and a majority of all the voters. So let's say there's 100,000 people in Australia. There's not. There's much more. But as long as 50,001 say yes to the tick, you pass the second part of the threshold being the majority of voters. But each state will have a different proportion of numbers. So New South Wales is quite a populous state. So is Victoria. South Australia, less populous. So there might only be 10,000 people in South Australia voting, and there might be 90,000 in the East Coast. Now, there's a lot more states than that, but what we need to show is that the majority in each of those states said yes as well. So you need 4 out of the 6 states to say yes, as well as overall. So that double majority is hard to get.
What about the territories? What do they give to that?
They're counted as well.
As a state? As one state?
I believe so. I believe they're on there. They're separate. I can confirm. I believe so. Yeah, they don't lose Port Northern Territory, imagine. Their votes aren't as valid. But know that process and how it works. If that's a hint, you can take it as you will. Section 51 allocates the powers under the Constitution. I would recommend having maybe a printout of Section 51 or having access to it. Now, when you're doing the quiz, you're not locked out of a browser, if you know what I mean. You can still Google and stuff. I don't recommend it, but if you want to pull up Section 51 on another screen, absolutely entitled to. Absolutely entitled to. So we know one of our sources of law is legislation, being laws that are passed by Parliament, also delegated laws, so regulation as well, or instruments like that. Now, legislation is always held at a higher level of precedence than case law. So, statute is better, it's paramount, and it can overrule any court decision as being what is legally binding. And why that is because Parliament is sovereign in that aspect. Now, courts do support legislation in a way, though, that they interpret the words of legislation. And that interpretation itself can create rules around how the law applies. So there is a little bit of overlap there. For a law to be passed, it needs to go through both houses. Now, generally speaking, the government that controls the House of Representatives will be the one that's passing most of the laws through. It's very rare that we'll see a private bill, which is someone who's not part of government, bringing an act through and being successful. Once it goes through the House of Representatives and the Senate, it then goes to the Governor-General for royal assent. Once it gets that stamp, it's officially a law. Now, it might have a date in it in terms of when it starts or when it's effective. Usually they do give us some time to prepare, luckily. But notwithstanding that, it's an act that is binding from the date that it's stamped. Now, the interpretation aspect, I think it's worthwhile brushing up on the different rules of interpretation. You may get a question that asks you, you'll get a sentence, for example, and then it'll ask you to apply a particular rule of interpretation to say whether another word would be included or not, for example. So we always start with the literal interpretation first. What is the literal interpretation of this word from a dictionary meaning? And if that creates a circumstance which is absurd or repugnant, the courts can start to rely on these different rules like the golden rule and the mischief rule to circumnavigate the literal approach. And then we've got class rules and those other rules that sound like Harry Potter curses. Remember those? They're all in Latin. A class rule is a good example of something you should be aware of, because if you've got a provision that talks about a certain class of goods, whiskey, gin, scotch, and then in that provision it might say those three things and then other like drinks. And then we've got someone who's drinking tea. We can tell from the class of that provision that it wasn't intended to include non-alcoholic beverages, because you've got specific, generous or generic classes within the provision itself. Likewise, if you get a clause that talks about vegetables, you can tell from that class that it's not talking about meats or even to a degree fruits. So a specific class is something that they can use to fill in the gaps. Excellent question, because they're so similar. They are so similar. The mischief rule is allowing the courts to go back to what the common law was before the legislation existed and determine what the Act was trying to fix. Why did they release this statute, and what was the mischief that they were trying to rectify there? So you're kind of going back to what was the state before. Whereas the purpose approach, what you're looking at is, well, what was the purpose within the legislation, or what was their intent behind the legislation? So instead of going to the rules before, I would go to things like the explanatory statements that Parliament released as part of the passing there. So this is looking at, well, what were the ministers thinking? What was the purpose? Well, this is looking at what was the law before. But you can see how they're so similar in that they probably come to the same outcome, generally speaking. Now, the mischief rule and purpose rule are broader than the golden rule. The golden rule, you're only looking at the document in its context as a whole. You're not really coming outside of it. Whereas where we look at the mischief and the purpose rules, you're starting to look at these extrinsic materials. It's probably more detail than you need, but good point in terms of the differences between those two. They, in paper, look the same. So I recommend knowing those. Brushing up, knowing where they are in your textbook. You will get questions on them, I can tell you that. This slide's a little bit early for some reason. I'll go back. The other source of law is judge-made law, common law. A person making a decision on a dispute, and then that decision creates what we call a reasoning or a ratio decidendi that is then a law. So long as there's no legislative law, it becomes law itself. Now, the slide before gives us the case names. And I think it's incredibly important for you to know what each section of a case name means. In terms of, we've got the parties' names first. Grant and Australian Knitting Mills. Who's bringing the action to court in those circumstances? Excellent. So the first person named is the person bringing the case. So Australian Knitting Mills is the respondent here. Now those parties can change hands depending on whether there's an appeal. So one of these might be unsuccessful in the first case. They might then appeal. Because they're the one bringing the case the second time, their name will then be first. And then this coding section, we need to understand what that means. So the brackets is the year the case was decided in. And then this numbering system is telling us, well, whereabouts in the law reports can we find it? The acronym CLR stands for the Commonwealth Law Reports. But there is a bunch of different ones that exist, such as the VLR, the Victorian Law Reports. You may get a question that asks, what year was this case heard or decided? Or what year was this, or what law report was this in? And then you'll have a list of all 5 things and you'll have to pick the best one. I think it's important that you know what that coding means. 54 means it's in volume 54 of the Commonwealth Law Reports, and this last number just tells us that you'll find this case on page 49, and then it'll probably go for 10 pages. We don't need this so much these days because everything's electronic, but think about in 1935, all this would have been published in a binding, and the only way to really find it was to be able to find it in a library in the day. So just know how that works. Now the common law system is built on this concept of precedent. The only way that the common law system works is by ensuring that decisions made by a higher court are binding on inferior courts in the same hierarchy. Now, this enables the court system to be quite flexible in terms of community standards as we go through, and it also can be precedent based on interpretation as well. Now, the key to precedent is the concept of ratio decidendi. And what that means is the reason for the decision or the principle. Generally speaking, this will just be 1 or 2 lines out of a case. Literally, this was the reason. The rest of it is what we call obiter dictum. Now, that could just be a conversation that the judge is having with themselves in paper. They could look like they're deciding on something and then turn away and then come back to a ratio. But the obiter is just discussion. And obiter is not binding, but it can be persuasive. In fact, most of a judgment will be obiter that is not really relevant in terms of you creating a law principle. Now, to use precedent, we need to also understand the hierarchy. Because a decision from a Supreme Court is binding on the lower courts, but a decision from a lower court is not binding on the Supreme Court. So the Supreme Court has the highest authority in the Victorian system, for example. But if a higher court, such as the family, or let's go the federal court in the Commonwealth system, makes a decision, because it's in a different hierarchy to the state court, that decision's not binding on the lower magistrates court over here. Yeah, it might be persuasive, because this is a nice high court, good judges, lots of experience. They might apply the same rules, but they don't have to follow them. Once they do apply it, though, it becomes a binding principle here, until it goes higher up, and it might change over time. So it can change its own precedent, but it can't change a precedent that is higher in the hierarchy. This is one disadvantage with common law, is that if you want to change the precedent, particularly if it's something that's all the way up in the High Court of Australia, you've got to go all the way back to the High Court to get that changed. That could be costly. The barristers up here getting 35, 40 grand a day. That's expensive. And to be honest, you're only going to get up there if you've got a real serious question to be asked, probably from a constitutional aspect. But notwithstanding having to go back to get the precedent changed, there's some things we can do, and one of those is called distinguishing. Distinguishing is when you can say that the facts are slightly different, so that that precedent doesn't really or shouldn't apply. The pure example I can explain is there's a spill on the floor, someone's wearing normal runners and they slip, and negligence is found in that aspect and compensation payable. Let's switch the fact a little bit though, and that individual that's walking is actually wearing roller skates and they slip. You can see that the lower court might say that that is a different fact pattern that should have another precedent created. So then they don't apply this one, they distinguish their own. But that's the only way they can really change it. They can disapprove of a precedent. They still have to follow it, but they might say, we don't think this is good law anymore. Still have to apply it, but it's signalling to the parties that, you know what, you should probably appeal this. You've got a chance. It's a good idea to know when a decision from a particular court in a particular jurisdiction is binding or persuasive on another court. You will get questions that ask you, hey, this court made a decision. Is it binding or persuasive on that other court? It may or may not be, but you need to know what the hierarchies and the jurisdictions mean. Cool. Equity. Equity is another type of law, so common law, criminal law, and then historically equity was by itself. Equity is an incredibly difficult concept and something in law school that we would cover over 2 whole semesters. So this is something you cover in one slide. So you don't have to go all the way into equity. But what equity is it's a way that it's something that the courts in England developed to overcome the harshness of precedent itself. So if we think historically, back to when the king started to delegate out to different parties to hear cases around the countryside in England, they were developing precedent, but what was happening was that the precedents that were becoming applied were sometimes not creating just or fair outcomes. So the parties would then petition to the king and say, we're not getting anything that really matches our needs. So the king would make a decision based on conscience or equity. And then eventually he got sick of hearing this, so he developed another body to start making decisions on equity. So we've got a common law system and an equity system being developed at the same time. And this occurred all the way up to about 1873, when we had legislation that combined the two. But in essence, equity will not apply unless the common law cannot rectify the situation. Under common law, all that you can get access to is compensation. Damages. But that doesn't help a party if they want someone to stop doing something or they want them to perform something. So an equitable remedy, for example, is an injunction. And that's in order to get someone to stop doing something. Let's say, for example, you've got someone who is drilling, I don't know why, but they're drilling a mine under your property. And that's then creating a circumstance where your house is vibrating or it's going to fall through. Yes, compensation might be good, but at the same time, what you're really looking for is an order to stop them from drilling under your house. You have to go to equity to get that. Similarly, you might have a neighbour that plays music really loud at 3 a.m. in the morning. You may not be able to seek much compensation for that. Maybe you've got loss of sleep, loss of enjoyment, but you're really looking for an injunction. On the other side is specific performance. Now, we'll talk about this in contract law in more detail, but let's have a circumstance where you've entered a contract with someone for a rare painting, a one of a kind. They then, after entering the contract with you, decide they're going to renege and not give it to you. Now, you may go to seek compensation, but if this is a one-of-a-kind painting, how much is it worth? So the courts might say in that circumstance, no, equity should subsist to make it a specific performance. So the contract was entered into, you will then have to perform that contract. Rather than getting money for it, they just have to give you the painting for what you were going to pay. So equity will only step in when common law isn't working. But the judges now can hear them at the same time.
Equity law, sorry, it's not part of criminal law, so like I think that particular example would have to perform, what would you do?
If they don't perform, then you're in breach of a court order. Criminal charges, contempt, all that. Yeah, so the courts are then involved in it, and if it doesn't happen, you'll be in trouble. And if a lawyer was to not follow a court order, you'd almost get struck off. So it gets pretty serious up there. So know the principles of equity, know a little bit about the history, but I think the most important part is to know what the maxims are. And that really means that someone who wants an equitable remedy needs to come with a clean conscience themselves. They need to bring it in a timely fashion. And I'm hearing things, it's all good. But good idea just to brush up on equity. Legal research. So there's two types of primary legal materials, and what primary legal materials are the laws themselves. So are you looking at statute, or are you looking at case law? They are the authority themselves. You do have secondary legal materials such as your textbook, but they are not the actual authority. They'll include references to the authority, but the best authority is referencing the case or the legislation itself first. When you go through your research assignment, even if you get the material from your textbook, if it's a case reference, just use it as a case law reference. Get your primary up. What I mean by that is if the textbook talks about Donoghue and Stevenson, just reference Donoghue and Stevenson in your research assignment. Just know the difference between primary and secondary. Secondary is not the law, it's an academic or an author writing about the law. Cool. Any questions about week 1 or the MCQ? Was that helpful? A little bit? Do we feel a little less like, oh my God, this is happening on Saturday, Sunday? Not really. Yeah, unfortunately, still have to do your reading. Just take your time. That's all I can say. Students before you've done this before and they've done really well, so there's no reason why you can't do the same. If you experience technical difficulties at the time, please contact me straight away. I don't want an email at 11:55 saying that, hey, Nick, I can't get access. I can see in the back end how long you've been in a quiz and whether it's collapsed on you, for lack of a technical word. But contact me straight away. I know we say RMIT, Royal Melbourne Institute of Technology, but sometimes that T is a little bit silent. So just make sure that if that does happen to you, get in contact straight away and I'll fix it. Awesome.